Breaking right now, Variety has just dropped a bombshell investigation into Prince Harry and Meghan Markle's.
He's had enough. He wants to clean the monarchy, and it's all now in the hands of the courts. Meghan Markle is in full mode panic along with Harry because they both know what they did.
Prince William has reportedly taken a firmer stance on issues connected to royal protocol and succession. And according to growing online speculation, that stance is now being interpreted by some commentators as indirectly affecting discussions around Prince Harry and Meghan Markle's children. Please subscribe. It cost you nothing, but it's really so much to me. At the same time, a separate legal case in Britain has drawn attention for raising broader questions about inheritance law and surrogacy.
King Charles didn't want to do anything about it given what's going on with Andrew, but in order for William to save the monarchy, he has to deal with the Archie and Lilibet problem.
And it is this case that many online voices are now linking, fairly or not, to the Sussex family. Recently, reports emerged about a high-value aristocratic inheritance dispute, said to involve around £157 million, being examined in a British court. Just the case centers on whether a child born through legally documented surrogacy qualifies as a beneficiary under very old trust rules that were written long before modern reproductive arrangements became common.
People think her kids are fake. They think they're AI.
I'm going to quote Tom Bauer by saying, he said, look, we all laughed at Samantha and she was right. And everything she said has come true.
Legal observers note that some historic trusts still contain language requiring heirs to be born of the body, a phrase rooted in centuries-old property and succession traditions. In court, a judge reportedly acknowledged uncertainty about how such outdated wording should apply in contemporary situations.
Something is happening right now in the courts, which is incredibly important, and nobody's paying attention to it because this will make history, and not in a good way for Rachel Meghan Markle.
For many analysts, the case highlights a wider legal dilemma. Traditional aristocratic and constitutional frameworks were not designed for modern family structures, and disputes like this may increasingly appear as society evolves. Because the British royal line of succession is also historically tied to the principle of legitimate birth.
Put an article out there that Meghan had a hysterectomy and couldn't have children, and that was a big issue in their relationship. So that says a lot to the fake royal kids right now, because obviously they couldn't have come out of her. So that's something that she obviously is going to have to deal with.
Codified most notably in the 1701 Act of Settlement, the discussion has naturally spilled into public debate about royal protocol. Commentators have begun asking whether similar legal interpretations could ever affect royal status or titles in theory, even though there has been no official suggestion that the Sussex children's positions are under legal review. The conversation has been fueled further by differences in how royal births have been presented to the public over time.
Marquess of Bath was open and transparent about this. So she is right now going through the legal process because as per the Peerage Act of 1963, that child born in the United States from a surrogate is not entitled to anything, inheritance or anything.
Prince William and Catherine, Princess of Wales, followed a long-standing tradition of appearing outside St. Mary's Hospital shortly after the births of their children, accompanied by formal notices signed by attending medical staff. These moments were widely viewed as part ceremony, part constitutional reassurance.
After, did you look like anyone?
We can figure that out.
Everyone says the baby's changed so much over 2 weeks. We're basically sort of monitoring how the changing process happens over this next month, really. But his looks are changing every single day, so who knows?
A way to maintain public transparency about the royal line. By contrast, the births of Archie in May 2019 and Lilibet in June 2021 were handled more privately. Archie was born at Portland Hospital in London, and the Sussexes chose not to participate in the customary hospital steps photo call. Later accounts from Prince Harry described a more personal and intimate experience surrounding the birth, including details about the environment in the delivery room and the couple's immediate departure from the hospital. Supporters argue that this reflected a deliberate effort by Harry and Meghan to protect their family's privacy and mental well-being after intense media scrutiny.
Markle has been incredibly quiet about the birth, but mostly the pregnancy of these children. Everything has been shady. The one who's been blabbing and saying crazy things is Prince Harry.
Critics, however, have said the departure from tradition created unnecessary speculation, particularly given the constitutional symbolism that royal birth protocols have historically carried. The broader issue now being debated in royal watching circles is less about specific allegations and more about how institutions adapt.
Obviously, when William was born and Harry was born and George and Charlotte and Louis, we got great pictures outside the hospital. I remember, and William and Catherine especially, they made such an effort to show the whole world their new baby.
As modern values around privacy, medical autonomy, and family life evolve, long-standing traditions rooted in monarchy and aristocracy can appear increasingly out of step. Legal disputes like the current inheritance case illustrate how unresolved tensions between tradition and modernity continue to surface. So far, Buckingham Palace has not indicated any change to the official line of succession or raised public concerns about the Sussex children's status. And our constitutional experts generally emphasize that such matters are governed by clear statutory rules and formal documentation.
But Meghan actually refused to use the hospital that was usually used by royals and refused to use all of the normal medical staff. And there was all of the weirdness over the timing of the birth of Archie.
Not speculation or social media narratives. Still, the discussion shows how quickly unrelated legal developments can ignite wider debates about transparency, protocol, and the future relevance of centuries-old systems. For some observers, Prince William's perceived firmness represents continuity, a signal that traditional frameworks remain important to the monarchy's credibility.
Had Harry on Spare talking about, how Meghan Markle, how complicated it was, how they went to the hospital, how Meghan Markle had to have 2 epidurals. We know all of that is BS. We know all of that is a lie.
For others, it highlights the need for reform as royal life becomes more intertwined with modern expectations. In the end, what is unfolding is less a single controversy and more an ongoing conversation about how historic institutions balance privacy, public trust, and legal certainty in a changing world.
This scandal comes as no surprise. Speculation about the children has been simmering for years.
Prince Harry has publicly described the birth of his daughter Lilibet at Santa Barbara Cottage Hospital as a deeply personal experience, even writing that he was physically involved in helping deliver her. For many readers, that account came across as intimate and emotional.
Silence everybody and just produce a DNA sample or proof of delivery. If you had those things, it would be very easy just to put them out there and say, this is what happened. This is what it is.
A father emphasizing connection and presence at a life-changing moment. However, in royal watching and constitutional commentary circles, the discussion often moves beyond the personal dimension and into questions about institutional tradition. In the British monarchy, details surrounding royal births have historically carried legal and symbolic importance because of their connection to succession. For centuries, the principle that heirs must be born of the body.
And a geriatric mother. The family claims and states that Meghan had a hysterectomy. How can a woman with a hysterectomy be pregnant? And most of all, why did the royal family go along with this? And what's going to happen now that this has come out?
Has existed within royal and aristocratic frameworks. In earlier eras, births were sometimes witnessed by senior officials to prevent disputes over legitimacy. While such practices have largely faded or evolved, transparency around royal births, including signed medical notices and public confirmations, has remained part of modern royal protocol.
Prince William knows that the crown cannot keep making the same mistakes in the past, that nobody who is not working royal can hold title.
Observers frequently compare the Sussex children's births with those of Prince William and Catherine's children, which followed well-established traditions, such as hospital steps, photo calls, and formal medical verification statements. In contrast, Archie's birth in 2019 and Lilibet's in 2021 were handled more privately. Supporters say this reflected the couple's desire to protect their family after intense media scrutiny.
At this point in time, King Charles doesn't understand that he cannot continue having Harry and Meghan on the British monarchy's website when they are absolutely trashing the very same institution and using titles for commercial purposes, which is basically repeating the same pattern that Sarah Ferguson has done and even Andrew did. That has to stop.
Critics argue that departing from precedent inevitably created speculation. Importantly, there has been no official indication from Buckingham Palace or the UK government that Archie or Lilibet's positions in the line of succession are under review or legally disputed. Constitutional experts generally stress that succession is governed by statutory rules and official documentation, not by online debate or commentary. The wider conversation has been influenced by unrelated legal developments in aristocratic inheritance law.
She wants all of the privileges that go along with an identity, but she doesn't want any of the responsibility. She doesn't want to do any of the work. She wants the tiara, she doesn't want the public service.
Such as recent court cases involving surrogacy and historic trust language. These cases highlight how older legal frameworks can clash with modern family arrangements. Some commentators have used them as a lens through which to discuss royal protocol, even though the legal contexts are not identical. Reports that Prince William takes institutional matters seriously are not surprising given his future role as monarch. As Prince of Wales, he is widely understood to prioritize continuity, credibility, and public trust in the monarchy. Discussions about the use of royal titles, particularly in commercial or media contexts, have also been ongoing since Harry and Meghan stepped back from senior royal duties in 2020.
The Peerage Act of 1963 clearly states, just like for royalty, that a surrogate cannot be used.
This tension between personal independence and institutional identity continues to attract attention. Ultimately, the debate reflects a broader theme: how a centuries-old constitutional monarchy adapts to modern expectations of privacy, changing medical realities, and evolving public communication norms. While speculation persists in media and online spaces, unofficial structures tend to move cautiously and rely on formal evidence and established legal processes rather than public pressure. For now, the Sussex children remain listed in the official line of succession, and no confirmed legal challenge has altered that status. The ongoing discussion says as much about public fascination with royal transparency and tradition as it does about any specific event. Questions about how surrogate-born children are treated in very specific inheritance or constitutional contexts are not really about celebrity gossip or personal opinions.
So many of them, and why it would have been so easy to be honest about who she is.
They come down to how older laws were written and how courts interpret them today. In the recent aristocratic inheritance dispute you're referring to, the key issue is that many historic trusts and titles were drafted using language that assumes a child is born of the body. In practice, that wording can create uncertainty when modern reproductive methods such as surrogacy are involved. Courts do not automatically extend old legal definitions to new situations. Instead, families sometimes have to apply formally for recognition, asking a judge to clarify whether a child qualifies under the original wording of a trust or settlement. That reality highlights how strict and sometimes outdated legal frameworks can still shape outcomes today. A parent may have to go through a visible legal process simply to secure their child's rights under documents written decades or even centuries earlier. When people then look at the monarchy, the scale of the issue appears much larger.
case about whether you think the birth was real, whether you think there was a surrogate, whether you think Meghan was wearing a moon bath. The fact is, Harry and Meghan lied. Buckingham Palace lied on their behalf. There was a complete cover-up over the birth of Prince Archie.
Yet the British royal succession is governed by a mix of historic statutes and constitutional conventions, including the Act of Settlement, 1701, and later legislation such as the Succession to the Crown Act, 2013. These are foundational rules that cannot be casually altered. Any major change would typically require parliamentary action and careful constitutional handling. Because of that, commentators sometimes speculate about hypothetical scenarios. For example, how succession rules would apply if modern reproductive arrangements were ever formally confirmed in a royal context. In theory, if a genuine legal ambiguity arose, Parliament could be involved in clarifying or updating the framework. However, constitutional scholars usually emphasize that such questions would only move beyond speculation if there were clear, official evidence requiring legal review. Another factor that keeps public debate alive is the balance between privacy and transparency. In some aristocratic or civil cases, matters are resolved openly in court, with detailed arguments and judgments on record. In royal matters, institutions often prioritize discretion and stability, sharing limited information unless a legal or constitutional necessity arises. Supporters see this as protecting family life and institutional continuity. Critics sometimes interpret it as leaving questions unanswered. Figures such as the Prince of Wales are widely seen as focused on safeguarding long-term stability for the monarchy. That includes paying attention to how traditions, titles, and constitutional rules are understood by the public. In that sense, your current discussions reflect a broader modern challenge: how centuries-old systems adapt to new social realities while maintaining consistency, credibility, and legal clarity. Ultimately, the inheritance case you mentioned illustrates a general principle rather than a direct precedent. It shows that historic legal language can collide with modern family structures, prompting courts or lawmakers to clarify the rules. When that happens, public interest naturally grows, not just because of the individuals involved, but because it touches on how long-standing institutions evolve in a changing world.